All rise. The Superior Court of the State of New York in and for Albany County is now in session. The Honorable David W. Pryor presiding. People of the State of New York versus Pat C. McIntosh.
Please be seated.
Hello. My name is Victoria Graffio, and I am an Associate Judge of the New York Court of Appeals, our state's highest court. In 2007, the New York State Mock Trial Tournament began its 24th consecutive year of competition. The program teaches students many valuable skills and life lessons that they can carry with them beyond their high school years. These lessons include the art of confident public speaking, writing concise and clear arguments, and the importance of the rules of civility. I am pleased to support this program because it teaches students about civic participation and the justice system we all live under in New York. I am always hopeful that students who are exposed to the way our courtrooms operate and the different components of a trial will graduate from high school with an increased respect for our judicial system and a willingness to support its important functions. After graduation, all former mock trial participants should become active, engaged citizens by regularly voting in elections, participating in jury service, and encouraging family and friends to do the same. Some mock trial participants will hopefully go on to serve the public as lawyers and perhaps even as judges. Now, let's talk about the basics of a mock trial. Before you begin studying your case and its issues, it is important that you understand the major components of a trial. We'll take a moment to review each segment and listen in as students perform each trial technique. The opening statements occur at the outset of a trial. An oral statement is made by each attorney to give the jury a preview of the case and of the evidence that will be presented. The purpose of an opening statement is to familiarize the jury with what it will hear and why it will hear it.
We are here today because of harassment directed at a college student, Jamie Gates. Mr. Gates was the victim of a series of threatening comments posted in his school's internet university's chat room. These comments talked about blood, pain, and torture. Even more terrifying, they indicate that the person behind him was watching Mr. Gates. As a result of fear inflicted by these comments, the victim's life was placed on hold, becoming a virtual prisoner in his own dorm room. Your Honor, the evidence including testimony from my three witnesses, Jamie Gates, Casey Warner, and Sheriff Investigator Ashton Hobb, will show beyond a reasonable doubt that the defendant was responsible for these terrorizing comments.
Today, we are here because of Jamie Gates and the messages which she received on the Big Apple State College message board. Your Honor, my name is Philip Chung. Together with Pushback Jaw and Marley Morris, we represent Pat McIntosh. Your Honor, in the opening statement, Mr. Monks has given us one summary of the case. Let's see what he didn't tell you. Evidence will show that this case is about someone being targeted. From the beginning of Investigator Ashton Hobb's investigation, he targeted my client, Pat McIntosh.
As a sophomore in college, Pat majors in psychology with a minor in criminal law. His fascination in these subjects allowed him to engage in intelligent conversations of the human psyche. Your Honor, what we have here is simply a case in which one is intimidated by the wit of another. And hopefully you'll be able to see how absolutely wrong it is for the prosecution to pin the wrongdoings of another on Pat. Thank you.
Direct examination is the initial questioning of a witness in a trial. A witness is a person who gives testimony under oath regarding something that he or she knows or saw. The direct examination is conducted by the party who called the witness to testify. During direct examination, The attorney generally may not ask witnesses leading questions, which are questions that suggest an answer.
State your name for the record, please.
My name is Jesse Clifford.
Go ahead, counsel.
Good morning, Mr. Clifford.
Morning.
Where do you work?
I work at Big Apple State College.
What do you do at Big Apple State College?
I'm a computer technician there.
What do you do as the college's computer technician?
I make sure that the computers are running properly.
Mr. Clifford, I'm now going to take you to the events of May 14th, 2006. What happened that day?
I received a call from my boss, Lauren Albert.
What did you do in response to this call?
I printed up the transcripts of the chat room from between the dates of May 9th and May 14th.
When you say transcripts, Mr. Clifford, what do you mean by that?
I mean every message that was posted in the chat room 24/7, without change, omission, or deletion.
What is the time period in which it's sent and which it is received?
Anywhere from a couple of seconds to a few hours.
So is it possible to delay the transmission from when it is sent to when it is received?
Yes.
Counsel, I've given you a little bit of leeway, okay? You shouldn't be directing the witness in any way.
During cross-examination, an attorney questions a witness who was initially called to testify by the opposing side. The purpose of cross-examination is to test a witness before the jury by bringing out contradictions in earlier testimony or statements, by suggesting doubts about the accuracy of the witness's recollection, or by trapping the witness into admissions that weaken the testimony. The cross-examiner may ask leading questions, which are questions that suggest an answer, but is limited to matters covered on direct examination and credibility issues. In any examination of a witness, either direct or cross-examination, there may be objections to the testimony, and the judge will decide whether to allow or exclude the testimony.
When you went to the bookstore, did it occur to you that bookstores sell their books?
Yes.
And that some student might have bought that forensics textbook?
Objection, Your Honor. Witness has no experience in libraries.
Your Honor, this is part of his investigation.
Why don't you rephrase your question? Go ahead.
Based on your own personal knowledge, do you know any students who bought a forensics textbook this year from the bookstore?
I do not know of any.
Did you investigate that in any way?
No.
Mr. Gates, isn't it true that you didn't go to the authorities until 4 days after you viewed the first comment?
Yeah, because it wasn't threatening, the first one. But over time, it got more threatening.
Even though your roommate suggested going to the authorities, you still didn't do so, correct?
I was afraid.
And you still didn't go to the authorities, correct?
Yes.
Thank you.
Each mock trial includes exhibits the attorneys can enter into evidence during trial to help them prove their case. But before the exhibits, such as photographs or documents, can be entered into evidence, an attorney must lay a foundation. A foundation is supporting evidence or testimony that proves that the exhibit is authentic and relevant to the issues at trial.
Your Honor, at this time, I would like to enter Defense Exhibit A for identification.
If you could show it to opposing counsel, please, and then approach, and I can mark it for identification. And mark Defense A for identification.
Mr. Gates, can you please identify this document?
This is my Big Apple College online chat room usage policy.
Okay. And is that your signature at the bottom?
Yes, it is.
Okay. Your Honor, at this time, I would like to enter Defense Exhibit A into evidence.
Any objection, counsel?
No, Your Honor.
Mr. Gates, can you please read aloud the last paragraph of that document?
Student uses a Big Apple State College.
The closing argument is the attorney's final statement to the jury. The attorney argues that the jury should consider the evidence and apply the law in his or her client's favor. During the summation, all of the evidentiary pieces should be brought together, and the case should be presented in a strong, fluid, and persuasive manner. The closing argument should be performed in a simple yet precise way.
The prosecution has not been able to prove beyond a reasonable doubt that my client is guilty. They have failed to meet their burden of proof and establish that Pat McIntosh is guilty. As past testimony clearly showed, Pat's only intention entering the chat room was to have an intellectually stimulating conversation with his peers, and at no point did Pat threaten or harass Mr. Gates. And the fact that my client's very dedication to his studies is the reason that he is being prosecuted is outrageous. Mr. Gates' very actions contradict his claims that he ever felt threatened or fearful for his physical, emotional, or mental health. Your Honor, all the prosecution has been able to prove is that my client's comments could be construed as creepy or uncomfortable. But that does not mean that they rose to the level of a criminal complaint or cyber stalking.
Your Honor, the defendant terrorized Jamie Gates over the internet chat room. He did so persistently and relentlessly, and these comments have reasonably left Jamie Gates feeling scared, panicked, and victimized. Your Honor, those are the elements of stalking in the second degree. The defendant singled out Jamie Gates and decided to stalk him. He did so by explicitly incorporating his nickname into commentary of suffocation, torture, and painful prolonged death. The people of the state of New York request that this honorable court find the defendant guilty of stalking in the second degree. Thank you.
Thank you very much, counsel. The court just needs 1 minute.
You have the opportunity to experience firsthand how our trial by jury system operates and how laws are applied in real-life situations by volunteering for a mock trial team. You will learn to identify the critical facts in your client's favor, how to prepare witnesses, and how to develop the theory of your case. Still not sure whether mock trial is for you? Students with mock trial experience will tell you that the benefits of participating in a mock trial program are numerous. Most importantly, they have gained confidence while learning about our justice system.
Realizing that a trial like this can go either way just depending on, what a lawyer does or how the judge interprets something, it really makes you think about the whole justice system.
Oh, it's no joke, mock trial. I mean, it seems easy, but it's very extemporaneous. You got to be with it. You got to pay attention nonstop, which is a lesson I learned when I had to go up there.
Now I know what the words mean, like hearsay before. I've heard it on Law and Order, but I never really knew what it meant. It's kind of enjoyable. Very enjoyable. It's enjoyable.
It was actually a lot of interaction between not only the attorneys and the judge, but the witnesses. It feels amazing to win. We definitely weren't expecting it. It was our first year. Yes, we're going to regionals.
With this trial, and because I was a lawyer, I argue a lot more with my family. We argue about everything now, and I usually win now.
You just get more confident in public speaking ability and just being able to talk to people, and you feel like you're just ready for more stuff. It feels awesome. It really, I like to win, and just knowing that you've put all this work in and you've actually gotten a result is pretty cool.
I hope this presentation has sparked your interest in volunteering for a mock trial team. Thank you and good luck.